This is the essay review of corporations, looking at corporate formation and pre-incorporation. The context of promoters. Promoters are persons acting on behalf of an unformed corporation. Looking at corporate liability for promoters' contracts. So the promoter is going to enter into contracts on behalf of the corporation. Corporation is liable for promoters' contracts when the corporation adopts by express adoption or by board of directors resolution or implied adoption. Implied adoption is where you have knowledge of the agreement and you accept the benefits of the agreement the promoter entered into. Promoter liability. The promoter remains liable on the contract until there is a novation. A novation is where the corporation is then substituted for the promoter in the agreement. Promoter is solely liable if the corporation is never formed. The promoter's duty. The promoter's duty to the corporation. The promoter is a fiduciary. They can get no secret profits. If property is acquired by the promoter prior to formation and sold to the corporation, the profit is recoverable if sold for more than the fair market value. If property acquired after corporate formation and sold to the corporation, any profit is recoverable. Continuing with corporate formation and formation requirements. To be a de jure corporation, which is a properly formed corporation or business that has fulfilled its requirements for formation. You must have authorized shares. You must have a purpose, and this can be a general purpose with a perpetual duration, and that is a valid purpose, and that is a presumed purpose, just a general purpose, perpetual duration. You must have an agent, so you have to have an agent act to represent the corporation, and you must also include the address of the registered agent in a filing. You must have incorporators, and the names and addresses of the incorporators, so the business owners. And the corporation must also have a name. This is some indicator of the corporate status, such as Inc. or Corp. So that's a de jure corporation, a properly formed corporation. Agent, authorized shares, purpose, agent, incorporator's name. You also have a de facto corporation in corporate formation. A de facto corporation is a business that does not fulfill the filing formalities to be a properly formed de jure corporation, but is treated as a corporation if the organizers have made a good faith, colorable attempt to comply with the corporate formalities, and they have no knowledge of the lack of corporate status. Legal significance of a corporate formation is that a corporation becomes a separate legal person. The shareholders are not liable for debts of the corporation because of limited liability. The shareholder is liable only for the price of their stock. The corporate formation and piercing the corporate veil. So again, legal significance is separate. The corporation is a separate legal person. It insulates the shareholders from liability. That liability can be pierced and the shareholder is held liable, and that procedure is called piercing the corporate veil. And piercing the corporate veil is available to avoid fraud or unfairness and to render the shareholders liable. Now, piercing the corporate veil requires that the shareholders treat the corporation as their alter ego by failing to observe sufficient corporate formalities. Or it can also be pierced where the corporation is undercapitalized. This is where the shareholders or the incorporators fail to maintain sufficient funds for foreseeable liabilities. Once the veil is pierced, who's liable? Shareholders active in the operation of the corporation are liable, or the director and officers are liable. Now, courts are more willing to pierce the corporate veil for tort liability as opposed to a contract claimant or contract liability. Now, looking at the action and liability of directors and officers of the corporation, statutory requirements: the board of directors must have one member at least. Shareholders can elect directors, and the shareholders can remove directors for any reason. Now, a valid meeting is required for board of director actions unless unanimous director consent in writing to act without a meeting. And notice can be set in bylaws. There are no proxies for or voting agreements allowed for board of director actions. An agreement would be, I will vote this way with you at all times, or you will vote with me at all times. Looking at action and liability of director and officers and liability of directors to corporation and shareholders. The directors have a duty to manage the corporation, but are protected from liability by the business judgment rule, but they are also fiduciaries of the corporation who owe a duty of care and a duty of loyalty. Liabilities of directors to the corporation and shareholders and the business judgment rule. There is a presumption that the directors manage the corporation in good faith and in the best interests of the corporation. Looking at the duty of care, because again, directors are fiduciaries and they owe a duty of care and loyalty. The duty of care is that the director must act with care a prudent person would use with respect to their own business. Looking at duty of loyalty. Again, directors are fiduciaries, owe a duty of care and a duty of loyalty. The duty of loyalty is that the directors may not receive an unfair benefit to the detriment of the corporation or shareholders. Now, they may receive an unfair benefit where there has been a material disclosure of the unfair benefit and an independent ratification, and we'll discuss ratification briefly, independent ratification by the corporation. Looking at duty of loyalty and self-dealing, this is where the director receives an unfair benefit in the transaction with the corporation, in a transaction with the corporation. And in the duty of loyalty, you have usurping corporate opportunities. This is where the director receives an unfair benefit by usurping an opportunity the corporation would have pursued. So duty of loyalty, the director is not liable to receive an unfair benefit when there has been material disclosure and independent ratification. Ratification can be by a majority vote of independent directors, by a majority vote of a committee of at least 2 independent directors, or by a majority vote of shares held by independent shareholders. Now, the interested director doctrine, this is under the common law, a transaction with an interested director is voidable at the corporation's option. So if one of the directors can breach their duty of loyalty and is an interested transaction, the corporation has the option of voiding that agreement. Looking at corporate officers, action and liability of directors and officers. Corporate officers, they have a duty of care and loyalty. Officers are agents of the corporation and binding the corporation by authorized acts. Corporate indemnification of directors and officers. Officers and directors and officers may be indemnified for costs, attorney fees, fines, judgments, or settlement in the course of corporate business, or from actions that result in the course of corporate business. Now, you never indemnify when the director and officer loses the suit. You always indemnify when the director and officer wins the suit. You may indemnify the directors and officers if the liability to third parties, so not the corporation, or settlement with the corporation. And the director or officer shows action in good faith, and the conduct is in the corporation's best interest. Looking at the rights of shareholders, shareholders have a right of direct action. This is where the directors breach a fiduciary duty owed to individual as a shareholder. Shareholders also have a right to a derivative suit. This is where the shareholder is suing to enforce the corporation's own cause of action. Other shareholder rights include a shareholder action for involuntary dissolution. This is where they can ask the court for liquidation if the directors are deadlocked and the corporation is threatened with irreparable injury or oppression or waste is occurring. Other rights, shareholder rights and issues are record books. They have the right to those. They may demand upon notice at the proper time. Shareholder rights and issues and dividends. The dividends are declared solely at the board of directors' discretion. They are limited only if the corporation is insolvent. You have two different types of corporations. You have a closely held corporation. This is an agreement among shareholders to eliminate corporate formalities. This requires unanimous shareholder agreement and articles, bylaws, or a filed written agreement. Now, there must be a reasonable share transfer restriction. Result is that there is no piercing. They may be S corp, and this may be formed as an S corp, where they have personal tax treatment if less than 100 shareholders who are individual shareholders by U.S. residents and only one class of stock. Looking at professional corporations, these are licensed professionals. Requirements are the organizers file with name as PC. Shareholders must be licensed professionals, only practice one designated profession, and the professional is personally liable for own malpractice, but not for other malpractice or obligations. Looking at fundamental corporate changes, and the types of fundamental corporate changes are merger, consolidation, dissolution, fundamental amendments to articles of incorporation, sale of substantially all corporate assets. Steps to fundamental corporate changes, they may be accomplished through board of director resolution, requiring notice of special meeting of shareholders, approval by majority of all shares entitled to vote, and by a majority of any voting group adversely affected. You have to file notice with the state. An example is an article of merger. One exception to this is where no shareholder approval is required for a short form merger, and that is where the parent company owns 90% of the subsidiary. Now, for corporate changes, a dissenting shareholder has appraisal rights, where a dissenting shareholder can force the corporation to buy shares at the fair market value. Requirements are before vote, file written notice of objection, and intend to demand payment. Looking at sales of assets in a fundamental corporate changes and sales of assets. Sale of assets may be considered a de facto merger and trigger rescission and appraisal rights. Dissolution and liquidation, approval by majority of directors and shares entitled to vote. And that completes our review of corporations for the essay.